The first thing I saw that morning was a wall of dirt where my irrigation canal used to be. For a few seconds, I honestly thought I was still dreaming. I stood at the edge of my property in the cold, gray light of dawn, staring at the fresh mound of soil stretching across the canal like somebody had buried it overnight. Then I noticed the orange construction stakes, and the red notice nailed to my fence, Wargarli Kilasadi PR Par de Violetiom. My stomach dropped, because that canal wasn't decoration. It wasn't an HOA amenity. It wasn't some ditch they could fill whenever they felt like it. It was the only reliable water source, feeding nearly 40 acres of my ranch. And 3 miles downstream, beyond the rolling hills and rows of grapevines, sat the most expensive vineyard in our county. A $9 million operation owned by the same people who had just decided my water was their property to control. I picked up the notice. My hands were shaking. The letter claimed that my irrigation canal violated a community drainage regulation and that the HOA had ordered it filled immediately. There was one sentence at the bottom that made my blood run cold. Failure to comply may result in additional enforcement action. I looked across the canal again. The dirt was still wet. Fresh tire tracks disappeared toward the gravel road. Whoever had done this had been here only hours earlier. I pulled out my phone and called the number printed on the notice. Nobody answered. I called again. Nothing. Then I heard an engine behind me. A black SUV rolled slowly down the gravel road and stopped beside the fence. The driver's window lowered. It was Margaret Whitmore, the president of our HOA. She was 61, perfectly dressed even at 7 in the morning, with silver blonde hair pulled into a tight bun and a navy blazer that looked completely out of place against the dust and mud. She stared at me through the window. Then she smiled. Not a friendly smile, the kind of smile someone gives when they believe they have already won. "Mr. Carter," she said, "I see you've received the notice." I looked at the canal, then back at her. "You filled my irrigation canal." Margaret stepped out of the SUV. "Correction. The HOA authorized remediation of an unauthorized waterway. That's been here for 70 years. That doesn't make it legal." I laughed because I genuinely didn't know what else to do. "My grandfather dug this canal, and your grandfather didn't have an HOA." She walked toward the fence. Behind her, 2 men in reflective vests were loading equipment onto a trailer. "You had no right to do this," I said. Margaret tilted her head. "We have every right. Show me the easement." Her smile disappeared. For the first time, she looked uncomfortable, just for a second. Then she recovered. "Everything you need to know is in the notice." "No, it isn't." I held up the paper. "There isn't a single parcel number. No county authorization, no survey, no court order." Margaret stepped closer. "You've been warned before about your property. My property. Your canal crosses a protected common drainage corridor. Then why isn't it on the county plat?" She said nothing. That silence told me more than the letter did. Something was wrong. Very wrong. I had lived on that ranch for 12 years. I'd inherited it from my father, who had inherited it from my grandfather. I knew every fence post, every cattle gate, every drainage ditch, and every bend in the creek. And I knew one other thing. That canal wasn't part of the OA. It existed decades before the subdivision around us. Margaret turned toward her SUV. "This matter is closed." "No," I said. She stopped. I looked directly at her. "You just made it a lot more serious." She turned around slowly. "Be careful, Daniel." Then she got into her SUV and drove away. I watched the dust settle. My wife Emily came running from the house. "What happened?" I handed her the notice. She read it once. Then again, her face went pale. "Daniel, I know. What are we going to do?" I looked toward the canal. "I'm going to find out who ordered this." That afternoon, I drove into town and went straight to the county records office. The clerk recognized my name when I explained what happened. She frowned. "You said the HOA filled the canal? Wes, do you have the parcel number?" I gave it to her. She typed for several seconds. Then she leaned toward the monitor.
"That's strange. What?"
"This waterway isn't classified as HOA property." I felt my shoulders loosen for the first time all day. "Can you print that?" She nodded. A few minutes later, she handed me a certified copy of the property map. The canal was clearly marked, not as HOA property, not as a drainage ditch, as a historical agricultural irrigation easement. And according to the county records, the easement predated the HOA by 38 years. I stared at the document. Then I noticed something else. A second notation had been added recently. Someone had submitted a request to modify the easement. The date was 6 weeks earlier. The applicant, Whitmore Agricultural Holdings, Margaret's family company. I felt my pulse jump. I asked the clerk for the original filing. She disappeared into the back room. When she returned, she looked nervous. "There is something you should know." "What?" "The modification request was denied." "Why?" "Because they couldn't prove ownership." I stared at her. "So they couldn't legally change it?" "Correct." "Then why did the HOA fill it?" She lowered her voice. "I don't know. I left the county building with copies of everything. But I wasn't going home yet." I drove toward the vineyard. From the hill above the valley, I could see thousands of grapevines stretching across the landscape. Rows and rows of perfectly aligned vines. The vineyard belonged to Whitmore Agricultural Holdings. It was Margaret's family's crown jewel. The county assessor valued the property and equipment at nearly $9 million. And something about the scene below bothered me. The vineyard's irrigation reservoirs looked unusually low. I pulled over. I watched for several minutes. No sprinklers were running, no irrigation trucks were moving. Nothing. Then my phone rang. It was my neighbor, Frank. "Daniel, where are you?" "Near the vineyard." "Get back to your ranch." "Why?" "Because there are people at your canal." I turned my truck around immediately. When I reached the property, I saw 3 vehicles parked beside the canal. 2 county trucks, 1 sheriff's SUV, and a white pickup with a surveyor's logo on the door. A man in a yellow safety vest stood beside the filled canal holding a measuring instrument. I parked and walked toward him. "I'm Daniel Carter." He looked at me. "Mr. Carter, I'm Evan Ruiz, licensed county surveyor. What are you doing here?" He glanced toward the mound of dirt, checking the location of the original irrigation easement. I stared at him. "Why?" He lowered his voice. "Because someone told the county the canal was never supposed to be here." My jaw tightened. "Who?" He didn't answer immediately. Then he looked toward the sheriff's vehicle. "That's what we're trying to determine." A deputy approached us. "Mr. Carter, I'm Deputy Harris. We received a complaint about unauthorized construction on your property." I pointed toward the canal. "The HOA did this." He looked at the filled canal. "Do you have proof?" I handed him the HOA notice. He read it, then looked at the surveyor. The 2 men exchanged a glance. "What?" I asked. Deputy Harris folded the notice. "This document says the HOA authorized the work." "Wes!" "But the county didn't." I felt a chill run down my spine. Then who gave those contractors permission? The surveyor answered quietly. "That's the problem." He pointed toward the canal. "Whoever filled this canal may have just interfered with a legally protected agricultural waterway." I looked toward the vineyard. Far in the distance, the rows of vines shimmered beneath the afternoon sun. Then my phone buzzed. It was Emily. I answered. "Daniel, you need to come home." "Why? I just got an email from the HOA. What does it say?" Her voice trembled. "They're fining us." "How much?" $25,000. I closed my eyes. "For what?" She hesitated. "Water theft." I looked at the filled canal, then at the county surveyor, then toward the distant vineyard. Suddenly everything made sense. They weren't trying to punish me. They were trying to make me look like the criminal. And if they succeeded, they wouldn't just control my canal. They could potentially control the water rights feeding half the valley. I looked at the surveyor. "Mr. Ruiz." "Yes." "How long can those vines survive without irrigation?" He stared at me. Then his expression changed. "Not long." "How long?" He looked toward the vineyard. "If their main irrigation supply is connected to this canal." He paused. 48 hours could be enough to cause serious damage. I felt the wind move across the empty channel. 48 hours. That's when I realized the HOA had made one enormous mistake. They had filled the canal without understanding where the water went, and now their own 9 million vineyard was sitting downstream, with no water. By sunset, the story had already started spreading through the neighborhood. I could tell because people who normally wouldn't even wave at me were suddenly driving slowly past my ranch. Some stopped, some took pictures, and one of them I noticed was filming the canal from inside a black pickup. I didn't confront him. Not yet. I had learned something that day. When people are trying to build a case against you, the worst thing you can do is give them evidence. So I went home, locked the gates, and sat at the kitchen table with Emily. The certified county documents were spread across the table between us. She stared at the irrigation easement. So they knew. Yes! They knew it wasn't theirs. Looks that way. And they still filled it. I nodded. Emily looked toward the window. Why? I didn't answer immediately, because I was beginning to understand. The HOA wasn't really interested in my canal. They were interested in what happened after the canal. The water flowed from my property into a network of agricultural channels that eventually supplied the Whitmore vineyard. If the HOA could somehow establish that the canal was illegal, they could force me to stop using it. And if they could control the waterway, they could potentially control the entire irrigation system. But there was something I still couldn't explain. Why would Margaret risk a lawsuit over a canal that wasn't hers? Then my phone rang. It was Frank. "Daniel, you watching the vineyard?" "No, turn on your computer." I opened my laptop. Frank had sent me a photograph. It showed the vineyard's irrigation pumps. Every one of them was shut down. Below the photograph was a message. "They're out of water." I looked at the clock. 8:43 p.m. It had been roughly 16 hours since the canal was filled. "How do you know?" Frank called. "I've got a friend who works maintenance there." "What did he say?" "He said the reservoir feeding the east fields is almost empty." I sat back. "How long before they have a problem?" "He says they're already having one." I looked at Emily. She had heard everything. "Don't celebrate," she said quietly. "I'm not." Because something still bothered me. If Margaret knew the canal supplied the vineyard, why would she shut it down? Unless she didn't expect it to stay shut down. Maybe she thought somebody would immediately reopen it. Maybe she expected me to break the HOA order. Then they could accuse me of violating the law. I called Evan Ruiz. He answered on the second ring. On the street. "Carter, did you find anything?" There was a long silence. "Yes." "What?" I located the original survey from 1987, and the irrigation easement is stronger than the current county map suggests. My heart started pounding. Explain. "The canal isn't simply an easement." "What is it?" "A dedicated agricultural water corridor." I didn't understand, he continued. "Your property has the right to maintain it. More importantly, downstream properties have documented rights to receive water through it. So the vineyard has water rights." "Exactly." I leaned back. "So if the HOA blocked the canal, they may have interfered with someone else's water rights." I stared at the wall. That changed everything. "Can you send me the survey? I can give you a copy tomorrow." "Why tomorrow?" "Because there's something else." "What?" His voice became quieter. The HOA submitted a different map to the county. "What kind of different map?" "A map showing the canal terminating before it reaches the vineyard." I froze. "That's impossible." "I know." "Who signed it?" Evan hesitated. "Margaret Whitmore." I hung up. For several minutes, neither Emily nor I spoke. Then she said something that made the entire situation feel much bigger. Daniel, yeah. What if they didn't make a mistake? I looked at her. What do you mean? What if they knew exactly what they were doing? That thought stayed with me all night. At 5:12 the next morning, I woke to a truck engine outside. I looked through the bedroom window. A county vehicle was parked at the gate. Behind it were two sheriff's UVs. I pulled on my boots and walked outside. Deputy Harris stepped forward. Morning. What happened? We received another complaint. From the HOA. He nodded. They claim you tampered with the canal overnight. I almost laughed. I was asleep. They say you attempted to remove the blockage. Deed no. Then why are you here? Harris looked uncomfortable. Because someone did. My stomach tightened. What? He pointed toward the canal. We walked down together. The mound of dirt had been disturbed. Someone had dug a narrow channel through the center during the night. Water was slowly moving through it. Not enough to restore the full flow, but enough to prove something. Someone had deliberately reopened the canal. Who did this? I asked. We don't know. I looked at the tire tracks. They weren't mine. They weren't county vehicles. They were heavy equipment tracks. Harris crouched beside them. These are fresh. I looked toward the road. Then I saw something, a small metal tag half buried in the mud. I picked it up. It had a serial number. Harris took a photograph. Don't touch anything else. I stepped back. What happens now? He stood. Now we figure out who brought the equipment here. Before he could finish, a black SUV came flying down the road. Margaret. She jumped out before the vehicle had completely stopped. What happened? Harris looked at her. That's what we're trying to determine. She pointed at me. He did this? I stared at her. You have cameras on my property now. You admitted yesterday that you intended to challenge the closure. That doesn't mean I broke into my own canal. Margaret turned toward Deputy Harris. You need to arrest him. Harris shook his head.
Or Mrs.
Whitmore, we don't have evidence Mr. Carter did anything. Her face hardened. This is an HOA matter. No, Harris said. It isn't. The two stared at each other. For the first time I saw fear in Margaret's eyes. It disappeared quickly. But I saw it. She turned around and drove away. The surveyor arrived 20 minutes later. He examined the disturbed dirt. Then he walked several hundred feet along the canal. Finally, he stopped. We struck. Carter. What? He pointed at a concrete structure hidden beneath weeds. I'd seen it hundreds of times, but I'd never understood what it was. This is a control gate. What does it do? It regulates the water going downstream. He brushed away dirt. Then his face changed. Someone installed a second gate. Where? Under the road? I stared at him. Why? To redirect the water. Where? He pointed toward the vineyard. Toward the Whitmore property. I felt a cold wave run through me. The canal hadn't simply been supplying the vineyard. Someone had built a system designed to control exactly how much water the vineyard received. Evan pulled out his tablet. I need to check something. He pulled up the county infrastructure records. After several minutes, he turned the screen toward me. There was a permit, issued 8 years earlier. The applicant was Whitmore Agricultural Holdings. The project description was simple private irrigation efficiency improvement. But the location was the same canal running through my property. That's on my land, I said. I know. So they built this without my permission. And Evan nodded, then he zoomed in on the permit. There is something strange. What? The permit lists a different parcel owner. I looked closer. The owner name wasn't mine. It belonged to a company I'd never heard of. Canyon Valley Water Management LLC. Who are they? Evan didn't know. So I called a lawyer. Her name was Rachel Morgan. She had handled my father's estate years earlier. When I explained everything, she told me to bring every document I had. I met her at her office before noon. She listened without interrupting. Then she spread the documents across her conference table. For almost 10 minutes, she said nothing. Finally, she looked up. Daniel, I think you're looking at something much bigger than an HOA dispute. That's what I thought. She pointed to the LLC. This company was created 9 years ago. Boo-hoo. That's the interesting part. She pulled up a corporate filing. The registered manager was listed as Margaret Whitmore. I stared at the document. So she owns the company, indirectly. What does that mean? Rachel leaned back. It means the HOA may have been the least important part of this. She tapped the irrigation permit. This company appears to control the infrastructure. Then she pointed to the county denial. And someone recently tried to change the legal status of your canal. I felt my chest tighten. Why? Rachel looked directly at me. Because whoever controls that canal may control the water. Silence filled the office. Then her phone rang. She answered. Her expression changed almost immediately. Who is this? She listened. Then looked at me. Put him on speaker. A man's voice came through the phone. It was nervous. Mistrekken. Carter.
Yes.
My name is... Who are you? I worked maintenance at the Whitmore Vineyard. What happened? I quit this morning. Why? He took a breath. Because I found something in the irrigation records. Rachel looked at me. What did you? Voice dropped. They knew the canal was going to be shut down. My heart stopped. Well, 6 weeks ago, 6 weeks. The same time Margaret's company had tried to modify the easement. Rachel sat forward. Tyler, what exactly did you see? I saw an internal projection. What projection? They calculated how long the vineyard could survive if the canal was closed. I felt a chill run down my spine. And Tyler was silent. Then he said 4 words I'll never forget. They expected it to fail. Rachel looked at me. I could barely breathe. The 9 million vineyard wasn't an accident. It was part of the plan. But if that was true, one question remained. Why would Margaret deliberately risk destroying her own family's vineyard? Tyler answered before I could ask. Because the vineyard isn't the real asset. Then the call abruptly ended. For several seconds after Tyler hung up, nobody in Rachel's office moved. I kept staring at the phone. The vineyard isn't the real asset. Those words wouldn't leave my head. Rachel broke the silence. Daniel, don't call him back yet. Why? Because if someone inside that operation is willing to talk, we need to know exactly what he has before anyone realizes he's cooperating with us. I nodded. Rachel gathered the documents into a folder. From this moment forward, don't confront Margaret. Don't threaten anyone. Don't touch the canal, and don't post anything online. I understand. We're gonna let them make the next mistake. She was right. The next morning, that mistake arrived in an envelope. It was delivered by certified mail. The HOA was suing me. Their complaint accused me of illegally obstructing a community drainage system, damaging HOA infrastructure, and interfering with neighboring agricultural operations. They were demanding $180,000 in damages. I read it twice. Then I laughed, not because it was funny, because the entire thing was upside down. They had filled my canal. Now they were accusing me of blocking it. Rachel read the lawsuit and smiled. Good. Very good. She pointed to one paragraph. They just admitted the canal exists. So, they're claiming it's OA-controlled infrastructure, which it's not, exactly. She pulled out the certified county map. Their own lawsuit is going to force them to prove ownership. And they can't. That's what we're going to find out. 3 days later, the first hearing was scheduled. By then, the vineyard had been without normal irrigation for more than 72 hours. The consequences were becoming impossible to hide. Local news helicopters had started appearing over the valley. The vineyard's east fields were visibly stressed. Some of the vines had begun wilting. Workers were moving portable water tanks across the property, but those tanks couldn't supply thousands of plants. The county agricultural office issued a notice warning that prolonged irrigation disruption could cause severe crop losses. The number everyone was talking about was $9 million, and Margaret was furious. She confronted me outside the courthouse. You've destroyed my family's business. I looked at her. You destroyed your own irrigation system. She stepped closer. You have no idea what you're dealing with. Rachel stepped between us. Ms. Whitmore, I'd recommend you speak through counsel. Margaret stared at me for several seconds. Then she whispered, you should have just signed the agreement. What agreement? Her face changed. She realized she'd said too much. Then she walked away. I turned to Rachel. What agreement? I don't know yet. But we were about to find out. Inside the courtroom, Margaret's attorney presented the HOA's case. He argued that the canal was part of a shared community drainage network and that I had violated HOA rules by refusing to cooperate. Then Rachel stood. She placed the certified county map on the judge's desk. Your Honor, the plaintiff claims this canal belongs to the law. The judge looked at the document. Does it? Rachel smiled. Nope. And she produced the original 1987 survey, then the agricultural easement, then the county's denial of Whitmore Agricultural Holdings' attempt to modify the easement. The courtroom became quiet. Margaret's attorney objected. Rachel continued. More importantly, the plaintiff's own complaint acknowledges that the canal supplies water to properties downstream. The judge looked toward the opposing attorney. Is that accurate? The attorney hesitated. Yes, Your Honor. Rachel nodded. Then we have a problem. She pulled out another document, a water rights agreement. It showed that downstream agricultural properties had legally recognized access to water through the canal. And one of those properties was Whitmore Agricultural Holdings. The judge leaned back. So you're telling me the HOA blocked a waterway that supplies one of its own members? Rachel answered calmly. Not exactly, Your Honor. She looked toward Margaret. They blocked a waterway that supplies the plaintiff's separate agricultural business. Margaret's attorney stood. That's irrelevant. Rachel turned toward him. Then perhaps this will be relevant. She handed the judge a corporate filing, Canyon Valley Water Management LLC. The judge read the document. His expression changed. Who owns this company? Rachel answered. The HOA president's family company. Margaret's attorney objected immediately. Your Honor, ownership of a private corporation has no bearing on this dispute. Rachel didn't argue. She simply said, then we'll address it at trial. The judge scheduled a full evidentiary hearing and ordered both sides to preserve every document related to the canal, irrigation system, HOA enforcement, and water rights. That order changed everything. Because now Margaret couldn't destroy the records, and she couldn't pretend they didn't exist. 2 days later, Tyler contacted Rachel again. This time he had evidence. He had copied internal maintenance records before leaving the vineyard. There were spreadsheets showing irrigation projections. One column listed projected losses from a canal shutdown. Another showed the estimated value of the land without active agricultural production. And a third column had a number that made my stomach turn. Estimated redevelopment value of $31.4 million. Rachel stared at it. So that's the real asset. I finally understood. The vineyard was worth about $9 million as an operating agricultural property. But if the irrigation system failed, the land could potentially be redeveloped. Housing, commercial property, luxury estates. The HOA had been expanding toward the vineyard for years. Margaret wasn't trying to save the vineyard. She was trying to destroy its agricultural classification. Then I saw something else. A list of parcels. My ranch was included. My blood went cold. What is my property doing on that list? Rachel scrolled down. Because your irrigation easement is in the way. The plan was suddenly obvious. If they could eliminate the agricultural water corridor, the vineyard could fail. If the vineyard failed, the land could be rezoned. If the land was redeveloped, the value would explode, and my ranch sat directly beside it. They weren't fighting over a canal. They were fighting over the future of the entire valley. 3 weeks later, the case went to the evidentiary hearing. The courtroom was packed. Neighbors filled the benches. County officials sat behind us. The surveyor Evan Ruiz testified first. He explained the original easement. He showed the court exactly where the canal ran. Then Rachel asked the question that changed the case. Mr. Ruiz, did the HOA have legal authority to fill this canal? No. The courtroom went silent. Why not? Because the HOA does not own the canal, the underlying easement, or the agricultural water corridor. Margaret's attorney stood. Objection. The judge overruled him. Then Deputy Harris testified. He described finding heavy equipment tracks at the canal and confirmed that I had not been responsible for the overnight disturbance. Then Rachel called Tyler. Margaret looked furious. Tyler walked into the courtroom carrying a folder. He explained the internal vineyard documents. He explained the irrigation projections. And finally, Rachel asked, Miss Tyler, did you see any documents discussing the deliberate shutdown of the canal? Tyler looked toward Margaret. Then back at Rachel.
Yes, what did they say?
They called it a controlled water interruption. The courtroom erupted in whispers. Rachel held up the document. Was there an expected outcome? Tyler nodded. They expected the vineyard to lose enough production that the property could be converted to another use. Margaret's attorney jumped to his feet. Your Honor, this witness is speculating. Rachel responded. He worked in the irrigation department and personally handled the records. The judge allowed the testimony. Then came the final piece. Rachel introduced an email. It was from Margaret. The subject line read Canal Enforcement Timeline. The email discussed the HOA violation notice, the canal closure, and the expected impact on agricultural production. But one sentence destroyed everything. Margaret had written, once the water issue is resolved, we can proceed with the redevelopment application. The courtroom went completely silent. Margaret lowered her head. Her attorney stopped objecting. The judge stared at the document for several seconds. Then he asked, Mrs. Whitmore, did you write this email? She didn't answer. Ms. Whitmore. Finally, she said, Wes. That single word changed the entire case. The judge ruled that the HOA had no authority to close the canal. He ordered the immediate restoration of the irrigation easement. He prohibited the HOA from interfering with the waterway, and he referred the matter to the county for investigation of the disputed permits and property filings. But there was more. The county suspended the redevelopment application. The agricultural designation remained protected. The HOA's lawsuit against me was dismissed, and the court ordered the HOA to reimburse my legal expenses. Margaret resigned as HOA president before the county investigation was completed. Within months, the entire board was replaced. The vineyard survived, but barely. The owners spent hundreds of thousands of dollars restoring the irrigation system and repairing the damaged crops. The 9 million vineyard never became the 31 million development Margaret had imagined. As for my canal, the county rebuilt the section that had been filled. They reinforced the banks, installed proper control gates, and recorded the agricultural water corridor permanently. One afternoon, months after the court case ended, I stood beside the restored canal with Emily. Water moved steadily through the channel. Sunlight reflected off the surface. Across the valley, the vineyard was green again. Emily looked at me. Do you ever think about what would have happened if you hadn't gone to the county? I looked at the water. All the time. Would you have sold? I shook my head. No. She smiled. Why? I watched the water disappear toward the vineyard. Because this wasn't really about water. She looked at me. It was about power. I nodded. They thought if they controlled the canal, they controlled the people who depended on it. I looked down at the old wooden fence my grandfather had built decades earlier. They forgot something. What? I smiled. Some things aren't theirs to control. A year later, the county installed a small historical marker beside the canal. It explained how the irrigation system had supported local agriculture for generations. There was no mention of the OA, no mention of Margaret, no mention of the 9 million vineyard. But every time I drove past that marker, I remembered the morning I had found a wall of dirt where the canal used to be. They thought they were closing a ditch. They were actually opening the door to the biggest mistake they'd ever make. And ever since that day, whenever someone asked me what happened when the HOA tried to take control of my water, I give them the same answer. They blocked my canal for a violation. And in doing so, they finally showed everyone who was really breaking the rules.